We also have very many distinguished friends of ours who came, and they came on very short notice, as it was explained. We did not want to come into the office and plan an occasion. Therefore, this was a very short notice. We have development partners. We are also grateful that you are able to come. Your Excellencies, we are very, very grateful. My speech will be very short because what I wanted to say has been said by many of the speakers who have spoken before me. And I want to say, since my nomination was announced, it was aptly described by many as a momentous occasion in the history of this country. And indeed it is, because this is one that assures every girl or boy, no matter their circumstances, that it is possible to keep dreaming, because Kenya is big enough for all of us, and she gives all people equal opportunities. This historic moment is a product of the opportunities afforded to me by Kenya and Kenyans. From my mother, Naomi Irangunto Rutere, to the retired judge of the Court of Appeal, the Honorable Mr. Justice Omoro, who recommended me after we sat for long hours at the GJ Rose, developing a blueprint for the reforms in the judiciary. He thought my passion and my cry for access to justice would find a place if I worked as a judge. I had never dreamt of being a judge, but he recommended me to the Judicial Service Commission, and I was appointed a judge, and I acknowledge my brother, Mr. Justice Omoro, for that. It is also the harvest of the seeds planted and nurtured by many women who have come before me with fasts. Allow me to name a few because I'm walking in their footsteps, beginning with Field Marshal Muthoni wa Kerema, who fought in the Land Freedom Army and was the only woman to be referred to as the Field Marshal. Priscilla Abwao, the only female member of the Legislative Council, who represented Kenya in the Lancaster House Conference. Grace Onyango, the first woman member of Parliament. Mrs. Nyiva Mwendwa, the first woman appointed as a cabinet minister. And of course, our very own, the retired Lady Justice Effie Owo, the first female magistrate, judge of the High Court and Court of Appeal, and many other unspoken and uncelebrated women who in their big and small spaces continue to break barriers and who have made the present for me become possible. The last 30 years of my life have been in service of the law. Beyond being a career, this has been a journey. I call it a calling, a privilege, and a life of commitment. I started off as an optimistic law student, juggling the roles of a young mother, a wife, and a student. I graduated with a bachelor's degree in law and gradually progressed to be a legal associate, and I'm proud to be associated with my pupil master, Mr. Wanjoki Mushemi, who is present in this room, putting my newfound knowledge to use in service of women first, who I found were disempowered, and learning how antiquated laws and delayed processes can further marginalize and entrench injustice. These lessons of disempowering of women stayed with me as I opened my own law firm and also joined hands with FINDA and others in pursuit of human rights for the most vulnerable. They would also inform my decision to defend those whose rights were infringed upon by the state during the one-party rule. As I argued cases for political detainees during the Moi era, I came to deeply appreciate the value of a judiciary that was impartial and free from influence and control of other actors. For how can an institution under the control of another be impartial and adjudicate fairly. For the scales of justice to function properly, there can be no undue influence. Not even a small stone or fingertip can be permitted to tip the scales. This belief, as well as the belief in human rights, the dignity and equality of every person, is what led me to lend my entire heart, my knowledge, and my soul, and I joined other Kenyans in the struggle for constitutional reform that would culminate in the Constitution of Kenya 2010. When I crossed the bar, moving from arguing cases before the bench to determining them on the bench, it was because I wanted to be part of the solution to the challenges in our justice system. That was almost 18 years ago, and in the judiciary, I have found very committed colleagues. I have found an institution that has progressively made great strides in ensuring greater access to delivery of justice to Kenyans. Serving first in the family division of the High Court, then as a resident judge in Nakuru, Kitale High Court, and then commercial division of the High Court, the Environment and Land Court, and finally the Court of Appeal. I have learned that changing the nature of the system is within our reach. I am delighted to be taking over the leadership of the judiciary at a time when the momentum for transformation is on an upward trajectory. I have witnessed many dramatic changes in virtually all facets of the institution of the judiciary since I joined. I would like at this point to express my sincere gratitude to the retired Chief Justice, Dr. Willy Mutunga, whose blueprint, the Judiciary Transformation Framework, set the foundation for the fundamental changes we are enjoying today, and to the immediate former Chief Justice, David Maraga, working very closely with her leadership, the Deputy Chief Justice, who gallantly sustained Chief Justice Mutunga's transformation with many initiatives that focused heavily on service delivery. Through the efforts of my predecessors, we now have a judiciary that is more accessible to the people of Kenya, a corps of judicial officers and staff who are sufficiently equipped to perform their duties with pride and confidence. There is tremendous improvement in physical and other infrastructure that has extensively been improved. There are the necessary structures for cooperation and coordination to engage the stakeholders that have been put in place, such as the court users committees. During my interview, ladies and gentlemen, I shared my vision of the judiciary that is independent, efficient, accessible, and responsive to the aspirations of Kenyans and a true guardian of the rule of law. My team will build working relations with other actors in the administration of justice to reach our court users and other parties with a view of building their capacity with knowledge that will empower them to bear their own agency and to become champions for justice. When everybody becomes an agent and champion for justice, I believe this country will start looking for our own indigenous solutions that lead to reconciliation and peace. Moreover, many will avoid violence, conflict, and other pitfalls or black spots that lead to endless court cases. To achieve this shared vision, one of my priorities, with your support, ladies and gentlemen, my dear colleagues, is building an efficient institution. I would like to round the judicial officers and staff who have developed a culture of innovation and inclusion in an operating environment with adequate resources in an effort to serve Kenyans to whom we are all beholden. This has meant judges, magistrates, caddies, and tribunal members working under enormous case rules with outdated modes available to them to deliver timely, efficient judgments. We are still grappling with unacceptably high levels of case backlog, despite the efforts of the last 10 years that had significantly reduced the number of old cases. Chief Justice Emeritus David Malaga's tenure focused on all courts concluding all cases that were 5 years old and above. We will continue that trajectory and ensure that at any given time, no case should be in the justice system for longer than 3 years. This is a target that is possible to achieve if we all embrace a case management system and the multi-door approaches that are now available to us, such as the court users committees, court annex mediation, small claims courts, and alternative dispute systems. Embracing the use of technology as a primary tool in our work has been a key focus area of transformation. When I look back at the past 1 year, I'm reminded of the truth that even in the darkest of human experience, there can be a bright side to it. When the COVID-19 global pandemic paralyzed judicial activities across the country early last year, it became necessary to expedite the adoption of technology, and we will continue to mainstream its use in our work, starting with the expansion of the electronic filing service and other ICT initiatives. In the world we live today, technology is the great enabler without which we cannot achieve our core service delivery objectives. To achieve this shared vision, the second area I request for your support is in improving access to justice. We are yet to achieve our constitutional commitment of establishing a high court station in every county. And I'm happy the Speaker is here and our Governor. And a magistrate's court in each of the 290 sub-districts. In some parts of the country, our people still have to travel for days on end to access the nearest court. We should always be conscious of the plight of the parties who come to court. Let us seek to understand what it takes for a party to appear in our courts, be they litigants, witnesses, or advocates. We all know too well that for some parties to find their way in our courts, they have made far-reaching sacrifices. Maybe to be able to come to court and to file a case, one has sold their only possession, be it the only livestock, and go to a cow to file a case or to find bus fare to attend court or even to pay a lawyer to represent them. We should always be aware of their vulnerabilities and frustrations. And this goes also for the big commercial conglomerates when they are involved in disputes. Small kiosk owners, peasant farmers, or victims of crimes, they all bear the burden of anxieties that are attendant to long periods of waiting for justice. A decade after promulgation, it is imperative that we expedite some of the promises of the 2010 Constitution so that Kenyans can realize the benefits. As an institution that generates almost 3 billion shillings annually, this revenue can be an important first step in addressing some of the challenges we currently face. I wish to note that the Judiciary Fund, which is established under Article 173 of the Constitution, is yet to be operationalized. We will continue to build the case for additional funding and a sustainable budget for these investments and judiciary functions based on our track record and needs of Kenyans. My role is to advocate for the resources to ensure that the structures needed are physically present at every court station so that every player can enjoy the fruits of this system. Additionally, I will champion for resources to revamp our data registry and technology system. Having served as the chair of the NCAJ Special Task Force on Children Matters, I understand too well the importance of the NCAJ in providing collaboration and coordination of the justice sector. I have spoken about the importance of a registration to anchor NCAJ in a statute that creates a structured mechanism for the cooperation and coordination among interbranch actors involved in the justice chain. I look forward to working with the National Assembly and indeed all stakeholders to help us develop systems and mechanisms that facilitates greater efficiencies along the justice chain and especially between the arms of government. I also want to recognize and applaud our development partners, such as the World Bank, the Ford Foundation, UNDP, UNHCR, IDLO, UNODC, the U.S. Department for Justice, among others, and we are grateful for their continued support. We pledge to continue to be prudent in the use of resources and to seek greater efficiencies to ensure value for money. With our independent fund in place, we can leverage resources from our partners interested in the administration of justice to respond to the needs of Kenyans. All coins, ladies and gentlemen, have two sides, and as I celebrate the tenacity and hard work of some of our officers and staff, I cannot be blind to those whose actions bring all of us down. I recognize corruption is endemic and problematic in two main ways. First, there are many corruption cases that are pending in our courts, and this has largely lowered the perception of the judiciary, and in this regard, the judiciary, which happens to be at the end of the chain link of justice, is regarded as the parking lot of corruption cases. Secondly, even though there are some structures for curbing corruption, such as the establishment of the Office of the Ombudsman, we have not succeeded to effectively deal with these cases. As noted by Chief Justice Mutunga in one of his addresses in 2016, he stated that the judiciary was under capture by agencies, and he named many. He said not only the government, not only the politicians, there is also the private sector, there is the civil society, there are ethnic cocoons, and there are also family members he named as people who are trying to capture the judiciary. This continues to be an active threat to the independence of the judiciary. My dear colleagues, the oath of office that I took so as to qualify to assume the office of the Chief Justice is not different from that which was taken by all of us, judges, magistrates, cadis, and members of the tribunals. No wonder in his after speech, after witnessing my signature, His Excellency the President was compelled to recite these profound words, reminding us we have to be impartial, we have to be independent, we have to be fair. Power to protect the Constitution vests to us, given by the people of Kenya, to render service with integrity and competency, among other things. These words should never depart our hearts, and the fact that the power to exercise that authority is donated to us by the people of Kenya. We should strive to be fair and expeditious in our work. We are servants of the people. One area we should all guard is the independence of the judiciary. And this takes me to the tenure of the Chief Justice Simbi Madan. He described the role of a judge in the following words, which we repeat often. A judge is a judge, whether he is newly appointed or an old fogey. The former has the benefit of his latest learning, the latter the advantage of experience. Both are people of honor and scholarly. Both are conscientious and judicious individuals, imbued with reason. Both are dependable and do not make wild surmises. Both act upon consecrated principles. Both get a fair share of juristic skills. Both are jealously scrupulous and impartial. Both are 24-karat gold. Both act free from doubt, bias, and prejudice. Both speak no ill of any litigant. Both are torchbearers for stability of society. Both are strugglers for liberty. Ladies and gentlemen, the challenges we are facing today about independence and impartiality of the judiciary is an old hat. These words were delivered in a judgment at a time when judicial courage was and decisional independence were rare. They continue to guide us today as we consolidate the gains achieved under our new constitutional dispensation. Justice Mandan set a high standard which we can achieve first as Kenyans and secondly as judges, judicial officers, cadis, and members of tribunals. Thankfully for us, judicial independence is anchored and ring-fenced in the Constitution. It behoves on every judge, every judicial officer to decline any invitation to rule on any case based on bias or ill will. Brother and sister judges and judicial officers, cadis, let us stick to the rule of law. Let us do that which the Constitution, the law, and our oath of office tells us to do. It tells us not to decide cases based on the direction of any party or authority. I also wish to assure you, colleagues, that we will respect and enforce the decisional independence of individual judges and magistrates. But we will also strive to ensure that all those who walk down the corridors of our courts will go home feeling that justice has been their shield and defender. While we will guard this independence jealously, we are equally aware that we are accountable. In the delivery of justice, we work with other arms of government and stakeholders. We are conscious that alone as the judiciary, we cannot succeed in delivery of services. My vision of the judiciary is that one that will constructively engage with the other arms of government for the mutual benefit of Kenyans. I see a judiciary which will be a leader in accountability and integrity. In my courts, I'm well known for regularly saying, let me conclude this matter. This is the same attitude and energy that I bring to the office of the Chief Justice. Let us conclude this matter. If there are cases to be heard, let us conclude them. If there are problems to be solved, let us resolve them. If there are barriers to overcome, let us overcome them. If there are changes to be made, let us make them. I invite you all to join me in this journey so that together we can move the judiciary and our country to a better, more secure future. I thank you all for listening. God bless you. God bless Kenya. Thank you very much.